Bonjour et bienvenue. Welcome to the Federal Court's webinar series marking our 50th anniversary. My name is George Locke. Je suis un juge de la Cour d'appel fédérale. Before we get started, I have a couple of housekeeping notes to share. First, simultaneous interpretation is available. L'interprétation simultanée est offerte. Please use the button marked with a globe or a sphere at the bottom of your Zoom screen to activate and control the simultaneous interpretation function. You have the option to choose between different audio settings, English or French or off. The latter means that you're listening to the main presentation in whatever language the speaker is delivering the remarks. Vous n'avez qu'à repérer le globe au bas de votre écran et de choisir la langue que vous privilégiez. All these instructions on how to access the simultaneous interpretation are also being posted in the chat for reference. Les instructions pour l'interprétation simultanée se trouvent aussi dans la boîte de discussion. The second housekeeping matter. Should you experience any technical difficulties during our time together, we ask that you send an email to the NJI help desk, whose email address is now posted in the chat, and we will do our best to assist you. Si vous avez des problèmes d'audio ou de connexion à la plateforme de la réunion, veuillez communiquer avec le service d'assistance informatique de l'INM et à l'adresse courriel qui figure dans la boîte de discussion. Nous ferons de notre mieux pour vous tenir en aide. Je présente maintenant le sujet de ce webinaire ainsi que nos conférenciers. Ceci est le troisième et dernier d'une série de webinaires offerts à l'occasion du 50e anniversaire des Cours fédérales sur différents sujets. Ce webinaire traite du sujet de la propriété intellectuelle. Nous vous encourageons à poser vos questions par l'entremise de la fonction questions et réponses Q&A. Donc, qu'est-ce que c'est la propriété intellectuelle, la PI, dans le contexte de ce webinaire tenu à l'occasion du 50e anniversaire des Cours fédérales? En général, la PI peut être n'importe quelle propriété qui ne possède aucune forme concrète ou matérielle. Cependant, dans le contexte de ce webinaire, ce qui nous préoccupe, c'est la PI en litige devant les cours fédérales. Les cours fédérales existent en vertu de l'article 101 de la loi constitutionnelle de 1867 pour la meilleure administration des lois du Canada. La portée de la compétence des cours fédérales est limitée par les exigences présentées par la Cour suprême du Canada dans l'arrêt ITO. Il y a trois exigences listées. Un, une attribution de compétences par une loi du Parlement fédéral. Deux, un ensemble de règles de droit fédéral qui soient essentielles à la solution du litige et constitue le fondement de l'attribution légale de compétences. Et trois, la loi invoquée dans l'affaire doit être une loi du Canada au sens de cette expression dans l'article 101 de la loi constitutionnelle. La loi sur les cours fédérales crée les cours fédérales et leur accorde certains domaines de compétences, voire surtout l'article 20 en ce qui concerne la PI. Les cours fédérales obtiennent aussi des domaines de compétences dans d'autres lois fédérales. Les cours fédérales sont des cours statutaires et leur compétence dans le domaine de la PI est limitée à ce qui est prévu dans les lois fédérales. Ceci englobe 4 types de PI traditionnels qui datent de confédération et pour lesquels les lois fédérales existent depuis les années 1860. Les brevets, les marques de commerce, le droit d'auteur et les dessins industriels. Pendant les années 1990, le Parlement a ajouté 2 nouvelles lois à ce groupe. La loi sur la protection des obtentions végétales, Plant Breeders' Rights Act, et la loi sur les topographies de circuits intégrés, Integrated Circuit Topography Act. Il n'y a aucune loi fédérale qui traite des secrets professionnels ou des renseignements confidentiels. La grande majorité du litige en pays devant les cours fédérales traite donc d'une ou de plusieurs des 4 types traditionnels de pays. Alors, quelles sont les particularités de chacun de ces 4 types? On commence avec les brevets. Les brevets existent depuis avant l'ère industrielle, quand la couronne accordait des monopoles sur la vente de certains produits commerciaux, ce qui risquait d'augmenter considérablement les prix de ces produits. L'inspiration du concept moderne des brevets était de limiter la portée de tels monopoles à des inventions nouvelles et utiles, et ça seulement pour un temps limité. Ceci avantageait le public par l'encouragement aux inventeurs de partager leurs inventions, mais ne limitait pas le commerce des produits qui existaient déjà. Aujourd'hui, sujet à plusieurs exigences, la propriétaire d'un brevet valide et non expiré a le droit exclusif de fabriquer, exploiter et vendre des produits qui utilisent l'invention. La majorité du litige dans le domaine des brevets concerne les questions de la validité du brevet et si leurs revendications qui décrivent la portée des droits exclusifs sont contrefaites. Beaucoup de litiges dans le domaine des brevets concernent le règlement sur les médicaments brevetés à vie de conformité, suivant lequel un fabricant de drogue générique doit surmonter les brevets listés vis-à-vis une drogue avant d'obtenir la permission d'entrer dans le marché avec sa version générique. The next of the traditional types of IP is trademarks. The idea behind a trademark is to permit merchants to identify their goods and services by the use of some recognizable mark, whether a word or design or even a sound or a smell. A trademark can act as a quick and useful way of indicating quality to potential purchasers. Think Porsche, Holt Renfrew, Apple. Generally speaking, vendors may not use marks that are the same or so similar as to be likely to cause confusion with another trademark. So confusion alludes to the idea that a potential purchaser of goods or services marked by one merchant might be led by the use of the mark to believe that those goods and services actually originate from another merchant. Unlike patents, trademarks may exist whether or not they're registered, and they can endure as long as the mark remains distinctive of the owner. The concepts of distinctiveness and confusion are often at the core of trademark litigation. Copyright is next. Copyright has its roots in the idea that artists should have the benefit of the value of their art, and therefore others should not be allowed to copy that art without permission. But what began as a relatively simple concept with modern technology and the enormous growth in the trade in copyrighted works has become a very complicated and fast-changing domain. So complicated and fast-changing that the Copyright Modernization Act put in place a review of copyright legislation every 5 years. The Copyright Act provides for a wide array of rights that are exclusive to the owner of the copyright, and these rights are subject to many exceptions. And all this helps to explain the complexity of copyright law. Copyright arises automatically upon the creation of the work and lasts a long time, typically beyond the life of the author, but not indefinitely as with trademarks. Copyright focuses on copying and does not prohibit production and sale of independently created works, unlike patents, for example. Sometimes copyright legislation is about whether a particular work or a portion thereof has been copied or independently created. But more often, copyright litigation concerns a dispute over the scope of the right and whether the owner has granted permission for an allegedly infringing dealing. And the final of the four types of traditional IP is industrial design. This concerns features of shape, configuration, pattern, or ornament, or any combination of those, that in a finished article appeal to and are judged solely by the eye. Registration gives the proprietor an exclusive right in the registration of the design. Amongst others, a requirement for registration is that the design is novel and does not consist only of features that are dictated solely by a utilitarian function. As IP rights, industrial designs are something of a hybrid. The creative aspects of industrial designs resemble copyright, but the application of industrial designs to commercial products resembles trademarks. Finally, the fact that exclusive rights in industrial designs can be obtained only by registration and last only a limited time resemble the patent regime. In fact, in many countries like the US, the equivalent of an industrial design is called a design patent. Compared to the other traditional kinds of IP, Canada does not see much litigation concerning industrial designs. So you can see that each type of IP has its particular characteristics and serves particular purposes. I'm going to now turn to introducing our panelists and their subjects. In order of appearance, you'll hear from Professor Jeremy De Beer, a professor of law at the University of Ottawa. Then you'll hear from Judith Robinson, a senior IP litigator and actually a former partner of mine. And then Justice Michael Manson, who's a judge of the federal court, will speak third. And rather than take up time for the webinar with respect to their very respective histories and accomplishments, I commend you to their biographies, which are included in the materials. Professor De Beer will begin with a review of his empirical study of IP proceedings in the federal courts over time, that is discussed in a chapter he and his co-author, Ryan Pistorius, contributed to the book that was published recently on the occasion of the 50th anniversary of the federal courts. Then Ms. Robinson will address bijural and bilingual aspects of the federal courts. And finally, Justice Manson will discuss recent efforts to improve efficiency in the federal court in dealing with complex matters, including IP matters. We plan for a period of for questions from attendees after the presentations, but some questions may come up during the discussions. And with that, I turn things over to Professor De Beer.
Thank you so much, Justice Locke. I'm going to share my slide deck with everyone. If you can give me a thumbs up if you can see the slides and hear me, great. Thank you very much for introducing this topic, Justice Locke, and for mentioning the book chapter on which this presentation is based. The book is really a wonderful collection, a celebration of the work of the federal courts, not just in the recent 50 years, but really since its inception. And this particular chapter builds on earlier work analyzing the federal court's jurisprudence in the area of intellectual property. In the last book to celebrate the court's work, intellectual property as a phrase appeared only 4 times in 447 pages. And when I set out to do the research and writing for this book, I was fairly certain that intellectual property would feature more prominently. And I wanted to work with a team of researchers to try to get an empirical understanding of just how important intellectual property is to the work of the federal court and the Federal Court of Appeal. And I wanted to acknowledge my co-author, Ryan Pastorius, who was instrumental in, especially in working to gather the data. My research assistant at the time, Almut McDonald, who's now a Federal Court of Appeal law clerk, was also key in helping to conceptualize the ways in which we develop the data set and present this kind of analysis. I'm indebted to the court's administration services, particularly Amélie Lavictoire, Andrew Bomberg, and Chantal Carbonneau, because the CAS really helped to compile a unique data set that facilitated this analysis. And I combined that with data available from some leading practitioners, in particular Alan Masek, who many of you will know runs the website ippractice.ca. And we integrated that data into the analysis with some earlier work that had been done by Ron Dimmick and Bruce Stratton prior to the 1993 period. So a lot of contributors to this particular chapter in terms of the research and the data and the analysis that deserve acknowledgement, and thanks to them. What I'd like to speak about for the next 15 or 20 minutes is an overview of our goals and methods that we use to produce this chapter. I'd like to present to you data and some of our findings about the workload of the Federal Court and Federal Court of Appeal in the field of intellectual property, and then analyze some of that data and open a discussion about why we see the trends that we see in the last 50 years at the Federal Court of Appeal and what we might see for the next 5, 10, or 50 years in the future. So we wanted to tell an empirical story of what was going on in the federal courts, and we focused on the last 25-year period from 1993 to 2018, which was the period during which we could obtain the most reliable and the best data. It was very tempting to describe and comment on the outcome of the fascinating cases that have been considered by the Federal Court and Federal Court of Appeal during that time. But I resisted the urge to make any sort of normative commentary on that body of jurisprudence, and instead just really wanted to describe a factual or empirical story of what's going on. We did combine quantitative data with qualitative data. We were able to review dozens of interview transcripts with dozens of current and former judges, and that contained a wealth of insight into why intellectual property is important, what the judges of the Federal Court and Federal Court of Appeal see as key milestones and contributions of the court in these areas. We also engaged in consultation with experienced IP scholars and experienced IP litigators to get their sense of whether we were on the right track with the quantitative data we'd found, and to try to get some of their insights into why we were seeing the trends we were seeing. And of course, the quantitative data that I mentioned earlier from the Court's Administration Service, Masek, Dimmick and Stratton, and others. So in presenting some of the data and the findings, I'll give you an overview first of the judicial and professional perceptions of the court's work in the field of intellectual property, and then present some figures and tables and charts that show you how the volume of proceedings is changing over time. And then break that down to a little bit more of a granular level, building very well, I think, on Justice Locke's introduction, and talk about the nature of the proceedings, whether they're actions, applications for judicial review, appeals, and the topic, copyrights, patents, trademarks, and so forth. So judges were asked to comment on fields in which the courts are distinguished, the fields in which the Federal Court and Federal Court of Appeal have distinguished themselves. And the respondents indicated that intellectual property tops the list when it comes to the areas in which the federal courts are distinguished. 84% of respondents mentioned IP, which far exceeds the sort of next cluster of acknowledged areas of expertise, administrative law even, Indigenous law, security and intelligence, immigration review, all hovering around 40 to 50%. So an extremely high degree of recognition that the federal courts are distinguished in the field of intellectual property, a finding that I think will surprise no one in this webinar, but is nice to see validated by the data in the interviews. That's not surprising when we look at the body of Supreme Court jurisprudence over a 25-year period from 93 to 2019, a period during which there were 40 intellectual property cases heard by the Supreme Court of Canada. Three-quarters of those, more than three-quarters of those, come from the Federal Court of Appeal, and the majority of the Federal Court of Appeal cases come from the federal courts, with the exception of a few cases that come via judicial review of Copyright Board decisions. So in comparison to the provincial courts, Quebec, British Columbia, and Ontario specifically, we see most of the big issues, intellectual property issues that go to the Supreme Court are coming from the federal courts, which I think is interesting. In the chapter, we break down the treatment of those cases, and what we observe is those are frequently split decisions. And so that was an indication to us that they're not straightforward matters. They're not cases that are resulting typically in unanimous decisions, or certainly decisions from the bench. They're complex and controversial cases that the Federal Court of Appeal is dealing with, Federal Court and Federal Court of Appeal, that are then going to the Supreme Court. In the chapter, we highlight one particular story as an example, the story of the federal court's jurisprudence around the patentability of higher life forms, going back to the Pioneer Hybrid decision in the late 1990s through the Harvard Mouse case, and then the Monsanto and Schmeiser case, and some subsequent treatment of those issues, as a really nice example of just how influential the federal court has been when it comes to the most timely intellectual property issues. We could have chosen to describe any number of other cases, but we chose that one. You can see more in the chapter. Quantitatively, intellectual property averages about a fifth of the federal court's work, and the proportions are similar for the Federal Court of Appeal. The slide that you're looking at here presents information on the federal court workload between 2000 and 2019. And it changes from year to year, but consistently intellectual property is about 20% of the court's docket, sometimes as high as 25 or 28%, never lower than 17 or 18%. So it's about a fifth of the court's docket in terms of proceedings. That's the federal court. We can look at the trend to break down what kinds of proceedings those are. That data I presented just a moment ago includes actions, applications, and appeals. Dimmock and Stratton, in a piece that they published, covered data from the 1980 to 1993 period, and they looked at actions and broke it down by topic. And what they observed during that time period was that those four key areas which Justice Locke described are in fact the areas where we see most of the intellectual property litigation happening, with trademark being the bulk of the court's docket, and designs being a relatively smaller proportion. What's interesting is we see a spike in the end of the 1980s in the volume of trademark litigation at the federal court. And we actually see that together when we combine that with data we receive from the Courts Administration Service and stitch it together. We see that trademarks from 93 all the way to 2017 were a high proportion of the federal court's workload, but a falling proportion. And I'll comment on and analyze that a little bit later. What we were able to do here is stitch together by combining Dimmock and Stratton's data with the data set that CAS helped us to compile, is present essentially a 40-year trend of litigation at the federal court. And you can see the English slide on the left, the French slide on the right, and on the left side of the slide, you see the data from 1980 to 1988 that we just showed you earlier, with a spike in trademark litigation around 1990. and then continuing using a different data set. So they were hard to compare, but we managed to do that work, continuing into the period 93 to 2017. Interestingly, in the early 1990s, we also see a significant spike in copyright litigation, and I'll comment on why I think that happened and what it might suggest for the future. The other notable observation here that I'd like to highlight is actually the yellow line changes in our analysis from the 1980s to the 1990s and 2000s, because industrial designs become, to be honest, a negligible portion of the court's docket and are replaced by this category of other, which includes most notably the patented medicines notice of compliance regime that Justice Locke described. And you can see that when you take a snapshot of what the federal court's workload was like in the period 93 to 95 compared to 2016 to 2018, for example. Now, I concede there was a little bit of arbitrariness in selecting, a 2-year period or a 3-year period or a 5-year period, and the numbers and proportions look a little bit different depending on what kind of a snapshot you take. But this is representative. In the early 1990s, we saw trademarks at almost 54% of the federal court's docket. And by the late 2010s, we see that dropping to about 40%. And what has filled that gap is the dark gray space of the patented medicines notice of compliance regimes, and a little bit more litigation in the area of patents. So that's quite an interesting observation in the way that the workload has changed from the early 90s, 25 years later. Fewer trademark cases, more patent cases, and patented medicine notice of compliance cases. You can see those PMNOC proceedings here in this particular figure, where we see a spike and a peak actually in the mid 2000s, around 2008. And that, I think, is quite interesting for those of us who follow the court's jurisprudence and activity around patents and patented medicines. I think that makes some sense, right? We were just seeing a lot of the questions coming up around the regulatory regime and working their way through the federal court system around that time, and then a gradual slowing down. And I'm going to comment on that again in the context of legislative change in just a few moments. Before I get there, I wanted to talk a little bit about the Federal Court of Appeal. So the proceedings we've just been looking at are federal court proceedings. The Federal Court of Appeal trend lines look similar, but different in a few key respects. One I wanted to highlight was the proportion of trademark cases at the Court of Appeal compared to patent cases. And so we see here in this figure from 1993 to 2017, as trademark cases were falling at the federal court, they also fell at the Federal Court of Appeal, naturally a couple of years later. But we see a relatively higher proportion of patent cases being considered by the Federal Court of Appeal. And by proceedings there, we're talking about appeals, not applications or actions. When we do a similar kind of snapshot that we just looked at with the federal court for Federal Court of Appeal data, we see the proportion of patent litigation staying about the same. We also see the proportion of trademark appeals staying about the same, slightly smaller. But what we see most notably here is a change in the type of copyright cases the Federal Court of Appeal is considering more recently compared to, say, the early and mid-1990s. In the early and mid-1990s, most of the copyright cases that the Federal Court of Appeal was dealing with were appeals from infringement actions at the federal court. We see a significantly higher percentage recently of applications for judicial review of copyright board decisions, which skip the federal court and go directly to the Federal Court of Appeal. And again, I think that's not likely to surprise observers and participants in the court's work in the area of copyright, but nonetheless quite interesting to see the numbers really reinforce what I think is most people's impression or perception. Just a couple of more slides before I wrap up here. This particular figure combines all of the data that we have: actions, applications, appeals, federal court of appeal. And we see a shift in the overall volume of workload at both courts. And it looks quantitatively like the volume of cases in the field of intellectual property at both courts is falling from 5 to 6, even up to 750 cases per year in the mid to late 1990s, to closer to 400 cases a year now in the late 20 teens. And so the data does show that there are fewer proceedings in the field of intellectual property than there were 25 years ago. I want to emphasize, still very important, it's still hovering around that 20 or 18, 19% of the workload level, but fewer than it was earlier, 25 years earlier. That, quite frankly, surprised us. Surprised us a lot. I would have thought that the Federal Court of Appeal are getting much busier, that the workload is increasing. So we spent a lot of time and talked to a lot of people trying to understand why this might be the case. And we came up with some hypotheses to explain this. Why is the ratio and number of cases lower? Well, we propose that the work is likely getting harder. And in support of that, that suggestion, we looked at what the Supreme Court of Canada is doing with cases coming from the Federal Court and the Federal Court of Appeal. And we're seeing these split decisions, these difficult cases. One of our hypotheses is that the simpler cases are settling, and particularly in the area of trademarks, possibly through arbitration and mediation, alternative forms of dispute resolution. The other hypothesis that we have is that the court's workload follows these cycles of change. Economic and technical change, of course, we're at the cusp of the fourth industrial revolution, and we saw massive changes in biotechnology and digital technologies in the late 1990s and early 2000s, but also international and legislative change. When you take the trend of different kinds of topics that the courts deal with, and you look at the proceedings that are commenced, there's a lag of 2, 3, 4, 5 years after major legislative changes, which are typically implemented in response to Canada taking on newer additional obligations in international treaties. And so we see this with, for example, a bump in copyright cases following the Phase 1 and Phase 2 and Phase 3 reforms to the Copyright Act. We see this in the area of patented medicines. We're already seeing early signs of another kind of change in litigation following the changes to the PMNOC regime. Changes in trademarks, on the other hand, are relatively more recent. So it was not until just a couple of years ago that Canada made major changes to its trademarks legislation, particularly around the use requirement, and well, we can get into that in the question and answers if we want. And our hypothesis is that we're just not yet seeing the bump in cases that are likely to result from those legislative changes. So to summarize, I've talked today about our goals and our methods, what we tried to do and what we didn't try to do. Presented just a few of our findings and a little bit of the data. There's much more in the chapter itself. And started with some of our analysis and hopefully opened a discussion. And again, let me conclude by saying how grateful I am to my co-authors and all of the participants who allowed us to do this work and to share it with you. Thank you very much.
Thank you, Professor De Beer. Before I hand things over to Ms. Robinson, I had, well, we've got a few questions, but one I wanted to ask now because it kind of builds on your acknowledgement that I guess the apparent decline in the number of IP proceedings that have begun in recent years is balanced by the increasing complexity. I wonder if what you'd say to the idea that IP proceedings were always more complex than the average matter before the Federal Court of Appeal, and therefore, would it affect the some of your earlier graphs about the proportion of IP matters to other matters, or specific to patents, the relative importance of patents compared to other areas of IP?
On the last question first, I think that's interesting. It makes sense that patent litigation would go to the Court of Appeal more frequently than trademark litigation when you think of the dollars at stake. So that just strikes me as not particularly surprising. The complexity is an interesting question. I would love to think that it's more complex, but then part of me believes that, of course, everybody thinks the area that they work on is more complex than the areas other people work on. And so I wouldn't want that kind of bias to skew my interpretation of the data. I'd like to believe that intellectual property is a complex and specialized area, but I wouldn't want to say that it's more complex or specialized than Aboriginal law or immigration, refugee law, or other fields where the court does fantastic work.
Sure, I hear you. I'm going to pass it on, but before I do, I just wanted to make one observation. You noted that Almut McDonald had helped you out on your work in this matter, and that she's now a clerk with the Federal Court of Appeal. She's actually my clerk, so I benefit this year from the same excellent assistance that you got in doing your work. So, all right, with that, I'll pass it on to Ms. Robinson.
Merci, Monsieur le juge Locke. Alors, bonjour tout le monde. Évidemment, je suis Judith Robinson et avec le juge Manson, nous allons poursuivre le discours avec un survol très rapide de quelques points saillants de l'évolution des litiges devant les cours fédérales en matière de propriété intellectuelle. Évidemment, j'espère avoir les commentaires du juge Locke et professeur de Beer ainsi que de vos questions et commentaires. Prochaine diapo, s'il vous plaît. Alors, vous allez voir les sujets que nous proposons de traiter. Là, c'est clair, c'est impossible de traiter de façon adéquate l'histoire riche des cours fédérales en propriété intellectuelle dans 1h30. Il y a tellement de points importants de droit, d'anecdotes amusantes, de contributions quand même notables. Alors, voici notre effort modeste. Avec la prochaine diapo, je débute avec quelques remarques sur le bijuridisme et le bilinguisme. Il faut d'abord reconnaître que dans le cadre des litiges en propriété intellectuelle, la nature bijuridique et bilingue des cours fédérales, c'est un sujet qui est plus amplement considéré par la professeure Martine Valois dans son chapitre contribué dans l'ouvrage présenté pour célébrer cet anniversaire. Et je vous invite à en prendre connaissance. Un petit rappel que, en vertu de la loi constitutionnelle de 1867, nous avons une dualité juridique et linguistique au Canada. Prochaine diapo. Qu'est-ce que c'est que le bijuridisme canadien? C'est la coexistence des traditions juridiques du droit civil de la province du Québec et du common law des autres provinces et territoires. Les cours fédérales peuvent être appelées à interpréter et appliquer les principes du droit privé provenant du droit civil ou du common law de façon ancillaire à leur juridiction. La loi d'interprétation fédérale facilite la complémentarité et la tradition bijuridique en prévoyant que le droit civil et le common law font pareillement autorité et tous les deux sont source de droit en matière de propriété et les droits civils au Canada. Prochaine diapo. Comment est-ce que le bijuridisme se manifeste dans les dossiers, dans les litiges de propriété intellectuelle devant les cours fédérales? J'ai tiré des exemples en matière de marque de commerce, les dossiers de Beam Suntory et SSE Holdings, où la Cour avait à considérer si une entente de règlement fut conclue entre les parties et, le cas échéant, les termes de l'entente en référant aux dispositions du Code civil du Québec. Prochain, s'il vous plaît. Je dois également mentionner le projet pilote sur le bijuridisme procédural introduit en novembre 2019. Ce projet pilote permet l'application du Code civil, du Code de procédure civile du Québec avec les adaptations nécessaires aux actions intentées devant la Cour fédérale, ainsi qu'aux appels en découlant déposés devant la Cour d'appel fédérale. Il s'agit d'une reconnaissance des différentes importantes entre la procédure civile du Québec et le droit procédural des autres provinces de common law. Les parties doivent être représentées par des membres du barreau du Québec. Le seul dossier en propriété intellectuelle dont j'ai connaissance qui suit le projet pilote en ce moment est le dossier Gérard McNichol-Tétrault, un dossier en matière de droit d'auteur qui est quand même à un stade préliminaire. Prochain. La composition des cours fédérales favorise et facilite le bijuridisme et le bilinguisme, en ce que la loi sur les cours fédérales exige qu'au moins 10 juges de la Cour fédérale et 5 juges de la Cour d'appel fédérale doivent avoir été juges des cours supérieures ou d'appel du Québec ou membres du barreau du Québec. Et donc, c'est clair que ça aide la compréhension du droit civil et également une facilité linguistique dans les deux langues. Le français et l'anglais sont les langues officielles des cours fédérales. Un exemple que je réfère en l'application de ces principes de bilinguisme et de bijuridisme devant la Cour fédérale, c'est un exemple personnel. C'est le cas du dossier Eurocopter contre Bell Helicopter Textron, un dossier en matière de brevet, le brevet canadien émis en français. La demanderesse et ses procureurs ont plaidé principalement en français. La défenderesse et ses procureurs ont plaidé principalement en anglais. Les procès ont eu lieu devant le juge Martineau, juge bilingue, sans interprétation au niveau de la Cour, évidemment, et les procureurs. Les interrogatoires et les contre-interrogatoires se faisaient dans la langue du témoin et les interactions avec la Cour, les plaidoiries, c'était une variété entre anglais et français et à l'occasion, tous les deux dans la même plaidoirie. Au niveau de bijuridisme, on était tous et toutes membres du barreau du Québec et donc on faisait à l'occasion référence à des règles de procédure du Québec. Alors vraiment une belle harmonie linguistique devant la Cour et la Cour peut être fière, je crois. Je pense que je suis à la fin de mes commentaires et je cède donc la parole au juge Manson pour poursuivre avec quelques éléments d'évolution en matière de procédure devant les cours. So Justice Manson, over to you for the next slides.
Thanks, Judith. I'm going to go through the headings with the slides and give you some anecdotal information as well. When I started back in 1982 in the patent trademark area as a lawyer, we would take years in trials, sometimes 4 or 5 years to get to trial, and then it would take often more than that. Ron Dimmick recently reminded me back in 2003, there were so many delays that the whole patent trademark bar, IP bar, wrote to the both Federal Court of Appeal and Federal Court to express dismay in how long it was taking to get to trial in any patent case. So we've come a long way in the last few years. In the last 5 years, particularly, patent trials are now being scheduled somewhere between 18 months to 2 years, typically from the commencement of an action. And the length of trials has been affected, particularly under the PMNOC, the pharmaceutical cases, where we have limited trials to 10 days, absent extraordinary circumstances. That's now been really translated into all patent actions and all IP actions, where absent, again, extraordinary circumstances, we're looking to get trials done in 2 weeks or less. And the expectation is that parties will do that, hopefully on agreement, but if not, with encouragement from the court. How have we achieved that? Next slide, please. Really, I think the best thing that's happened in our court, and certainly since I've become a judge, is the introduction of case management, effective case management. What we've done is have earlier trial dates. We have better efficiency, more timely, shorter discovery. And I'll just give you from our guidelines that committee of our court, our case management committee, in consultation with the IP bar, who were instrumental in helping us achieve better efficiency, was that we would start to have electronic documents more prevalent and are encouraged by the court. Discovery planning early with the case management judge, who's assigned almost immediately on patent action being filed. And if it's a complex trademark case, likewise. We have limits on oral discovery that we've introduced. If it's 1 day for trials of 5 days or less, 2 days if it's a 6 to 10 day trial, 3 days if it's 11 to 20 days, and 4 days for 21 days or more. So that is a huge difference from the 1980s and 90s, when discovery went on forever. You'd have 3, 4, 5 rounds of discovery. There'd be jockeying among counsel and parties, and that has been discouraged. And again, I think with education by counsel to their clients, we've seen a lot more cooperation in discovery and more streamlined discovery, which again reduces costs, and certainly in terms of access to justice for some of the smaller clients that are involved in IP litigation, makes a world of difference. We have in the discovery aspect limits on refusal motions, and we've introduced cost sanctions if there's unnecessary refusals being made by parties. Expert evidence, we've made sure that it's limited, that there's 5 experts per party. Again, in the old days, you'd get multiple experts on multiple issues, which led to huge time inefficiencies and certainly more complexity. Experimental testing, there's got to be reasonable notice, and at least 2 months before the scheduled service of expert reports, you have to alert the other side. Again, it helps a lot of the jockeying that goes on being eliminated. Pre-trial management preparation, trial management conferences. One of the things that in the last 5 years particularly we've done is we've had trial judges involved much earlier in litigation. And what that does is allows the case management judge, typically prothonotarians in our court, to bring in the trial judge on issues of evidence or issues that really should be determined by the trial judge in terms of what will go on at trial. And so whether it's meant or not, I think counsel and parties understand that from the get-go in IP actions now, the trial judge is there. And it may be in the background with the case management judge doing the day-to-day work, but the trial judge is aware of what's going on and involved much earlier than we used to be. Agreed statements of fact and joint books of documents. Again, we used to play lip service as lawyers to that without really doing anything, and nobody would agree on anything in terms of what they should or could agree to. I think there's been a push, certainly by our case managers, and I have to say that the prothonotarians in our court do an amazing job, and I think counsel will agree that they have made the whole litigation process much more efficient and effective than it used to be. Compendia for use at trial. Used to be that you'd have reams of documents in trials. Now we have, with the help of counsel and parties, shorter compendia that list just the most important aspects that the judge needs to refer to, which again makes a world of difference for trial judges in effectively managing documents and what's going on in the court. I mentioned earlier, PM&OCs are 2 weeks or less. The other thing that we've been working on, it's in a work in progress, is claim construction charts. And I'm focusing mostly on patents because they are the most complex and lengthy of our trial matters. And I have to say that there was some resistance early on, 7, 8 years ago, when we said to counsel, look, we want claim charts. We want you to tell us what's really an issue here in terms of expert testimony. And let's get what's agreed to and what not agreed to clear on the record. So when you come to trial, judges understand what's left in terms of the real dispute. Over a lot of consultation with counsel, we've now, I think, more effectively found that if we get those charts a few weeks before the trial, as opposed to earlier on in the process, it helps the parties and the judge understand what really is left in dispute and should be focused on during the course of the trial. So all that has been really helpful in shortening trials, in shortening the lead up, and in terms of cost effectiveness has been a world of difference for counsel and parties. Next slide, please. One of the more recent phenomena in our court, which has been upheld by the Court of Appeal in a number of cases, is the use of summary trials. I remember many years ago when I was a lawyer that if you were doing a summary judgment application, as soon as you could raise credibility or a genuine issue, it was game over. You had to go to a full trial because the judges would say, well, no, we've got to have a full trial as long as credibility is an issue. We then introduced summary trials, which is based on Rule 18A of the BC court rules. And what that's done is allow judges now, even if there's a genuine issue, or even if there are credibility issues, if the judge is of the mind that they can make the determination in a summary fashion, they do so. And we've had in the last few years a number of summary trials and to a lesser extent summary judgments that have been held by this court in complex patent matters and trademark matters and have been upheld by the Court of Appeal as being appropriate in doing so. Next slide, please. So I just had my clerk pull down some stats. And if you look in the last 10 years in terms of summary trials, summary judgments, this gives you an idea of how many have been granted in both in trademarks, copyright, and patents. That those statistics wouldn't have existed 10 years ago in any way, shape, or form. So you can see that the trend is to be more effective in terms of summary trials in our court. And again, then if it goes up to the Court of Appeal, there's a much more focused approach on what needs to be determined at the appellate level. Next slide, please. So last comment I'll make, and Judith's going to come in with some comments, I know. What's happened in the last 2 years with the pandemic and the new digital age? Well, obviously, for some time, there were no proceedings happening in our courts. And then we slowly ramped up, and some would argue that we may even quickly ramped up to go to virtual hearings through different platforms, whether it be Zoom or Microsoft Teams. And that is still here today. It's been prevalent throughout our courts. What we're now getting to as the pandemic is lessening, or at least we're getting more immunity in the marketplace, we're seeing a more in-person hearings starting again, slowly. I've had a number of hybrid hearings where we have counsel in court, but expert witnesses in Europe or the United States may be testifying by Zoom. And I think that's probably a trend that we're going to see in the future. Certainly in terms of a cost to parties, it makes sense if you don't have to bring your witnesses from other parts of the world to the court in Canada. It makes sense to do it if it can be done in a meaningful way and a fair and equitable way for the parties. So I think that we're going to see some form of hybrid hearings. Sometimes even on the smaller matters, we're going to have them continue by virtual hearings. But in the complex trials, my feedback I've had from counsel is that the preference is still to go back to in-person hearings, where you get a sense of the dynamics in the courtroom. It gives counsel opportunities to walk outside the courtroom and perhaps resolve issues during the course of hearings, which you can't do in the virtual world. So while the virtual world has been very good during these tough times, it's not something I think that lends itself well to complex proceedings. And obviously through electronic filing, we get less paper and it's more effective, and it allows better access to justice, more efficient use of our court time and resources, and less costly proceedings. So end of the day, we're going to have electronic or digital type proceedings as part of our future. That I have no doubt, and certainly we're still doing it today. And I would leave that to open up questions and other issues. And Judith, I don't know if you want to jump in on these last issues.
Sure. Certainly to echo Justice Manson, your observation of how big a change there has been in the speed of matters getting to a determination before the federal courts. Like you, I have recollections of very lengthy time to trials back in the good old days, and in particular, thinking of the first trial that was presided by Justice Hughes, where it took us 10 years to get there. Now, that was, as much in the hands of the parties, certainly, because as we know back then, the procedure didn't even allow you to have contact with the trial judge or have a trial date until you were really well along. And so the changes that have come through now push, with the assistance of case management, the parties towards a hearing, and the involvement of the trial judge and really effective case management that we have with the protonotariys is fantastic. Yes, there are still certainly some nuts and bolts in the sausage making, if I can put it that way, around some of the elements that can use some adjustment, I'd suggest. Notices to admit, of course, and getting to your agreed statement of fact notices to admit seem to remain a strategic make work project in my experience. And I think folks are still quite nervous about claim construction charts, although most, I think, would agree at the bar that the sooner that you can crystallize the key arguments around claim construction, the better off we are. And I guess the final thing that I'd offer up in terms of the summary judgment and summary trial experience, I was quite struck in the statistics that you prepared with the fact that even in the patent side, in the last couple of years, 2020 and 2021, I think it's 5 on 5 of the cases have at least a partial determination, if not the full motion being granted. So that really is a big change. And I note quite recently that Justice McAfee rendered a decision in a copyright infringement matter where he granted summary trial. So it continues to work its way through and be felt as a really important change.
I'd ask Justice Locke what he thinks from the appellate level on the idea of the summary trial. I mean, there was when we were lawyers way back when, the McNeil case kind of made it very difficult to go up on a summary judgment issue. But recently in the Court of Appeal, it seems that there's certainly been a way more open attitude about considering it. How do you look at it from the appellate level?
Yeah, and certainly the introduction of the rules specific to summary trials made that much more feasible. It's deliberately written to be a flexible tool for courts to use, the Federal Court of Appeal would recognize that and not want to interfere with an intended and proper use of the rules. There's another area that I see as a bit of an evolving aspect of the work of the courts that may reflect on efficiency, and I wanted to get your thoughts, Justice Manson or Judith, on it's to do with the availability of interlocutory injunctions. When I started in this business in the early 90s, the general view was if you wanted an interlocutory injunction, you had to go to a provincial court. I was in Quebec. You had to go to the Superior Court because you weren't going to get one from the federal court. Last few years, I've seen some come up, and that does seem to be an evolving area. What sort of effect do you think that's having on the efficiency of the courts?
Well, in terms of certainly trademark cases, I think injunctions have been alive and well for a number of years. In patent cases, the idea was that irreparable harm was very difficult to prove if damages were an adequate remedy. And that being the case, it was really, really difficult to get an injunction in a patent case. I think recently, or more recently, and we've had this discussion at forums with the IP bar, if you can show real damage, real irreparable harm in terms of economic license deals or something that gives a hook to the court to show that there is irreparable harm that won't be quantifiable, that there's more an open mind to say, yeah, maybe an injunction is appropriate. But I don't know if Professor De Beer has done any look at the injunction side of the equation in stats. But I would think it's still not very likely that many come forward in patent cases for injunctions.
Well, I would only observe that there's a comment in the question and answer forum that similarly addresses this as potentially one of the reasons for a decline in the volume of trademark cases. And that's maybe not perfectly consistent with your explanation, Justice Manson. The data that we looked at was based on proceedings commenced. And so when a document is filed, the Courts Administration Service automatically tags that in a certain way. And so one of the things about our data is that even if the cases are settling, if they're settling after a proceeding has been commenced, it still, looks as if it's a unit of activity for the courts in our data. So when we see those declines, what we're showing is actually a decline in the volume of essentially proceedings triggered by the filing of a document, whether it's a notice of action or application or whatever.
Judith, how about from your end?
Well, just touching on the injunction point, I would certainly agree, Justice Manson, in the patent world, it remains a hard slug. What I find quite interesting in terms of the evolution of the law is to see the way that I'm thinking in particular of the Federal Court of Appeal, Justice Locke's decision in Tech Savvy, how injunctions are now expanding into new and current areas of technology with things like, I guess that was a site blocking order, mandatory injunction based upon, the principles of CBC. So even if we continue to have some of our challenges, I would say obtaining interlocutory injunctions, depending on subject matter, the court seems to be stretching into areas of technology in a responsive way to meet some of the current realities. Justice Locke, did you have any thoughts or comments on that line?
I want to be careful about anything I might say about Tech Savvy at the moment. So I guess I guess I want to elaborate on that issue. I did want to make a couple of other comments about things that came up specifically. So these are not really questions so much as comments. With regard to the bilingualism of the court, this is. I'm hopeful that these two comments will be useful for people who appear before the federal courts. With regard to bilingualism, there is a provision of the Official Languages Act that requires that decisions of either of the courts that issue in a case where the pleadings have been heard in both languages, that the decision issue in both languages at the same time, with very narrow exceptions. And I've seen it many times where counsel, I've even seen it from the bench, believe that it's possible that with consent, we don't have to comply with that rule. That is not permissible under the Official Languages Act. So it's the usual practical result is it takes the extra time involved in doing the translation to get a decision out. Depending on how urgent the matter is, we can accelerate those things. But I have, in a few cases, been alarmed that where I couldn't justify saying that a matter was urgent, it takes as long to translate the decision as it took to write in the first place. So effectively, in a case like that, it would double the time to get the decision out. So that's just to give some people a sense of what can happen. There was also a comment about compendia. And I find that, so one thing, and I guess is being better understood, is for a compendium to be useful, it has to be relatively short. A 6-volume compendium, and I have seen that, is not so useful. And I think that kind of ties in with what the compendium is used for. I find that most of the time, it's not just a book of key documents. It is a aide-memoire that the counsel uses in their closing argument or their argument for our court to take us through. So it's sort of a chronological support for the things they're going to say in their submissions. And that can be useful for me when I go through my notes if I'm writing a decision. But other than being helpful looking at the notes, it's less helpful as that sort of compendium. And I guess I wanted to ask well, I'll start with Justice Manson, because you talked about hybrid hearings. My understanding is that our court has just stopped doing hybrid hearings. So they're either entirely in person or they're entirely virtual. And I'm told that that is because trying to do the hybrid hearing where some are in court and some are not was proving technically difficult. And I wanted to get a sense of, I mean, it's different in a trial, I guess, because you may not have much choice, but I wanted to get a sense of to what extent you've seen technical difficulties in trying to do these hybrid hearings.
Yeah, surprisingly, not much. I've had 4, I guess now, with witnesses in Europe or the United States testifying. And I've had it where counsel in Calgary were remote and counsel in Toronto were in the room with me. And I remember there was a suggestion at one point, could there be a perception of bias or unfairness? Because if you're not in the courtroom and your counsel outside the courtroom, that might somehow affect how the judge perceives things. And I said, not jokingly, because it was true, that actually the first one I did where counsel were in Calgary and there were counsel in Toronto in the courtroom with me, it was the counsel in Calgary who succeeded. So it obviously didn't affect the result in that case. And I think if you have, and it really, again, gets down to our registry people being very effective. They have done dry runs with the remote witnesses, with counsel. Counsel have done that so that by the time it comes to the actual trial judge, all the blemishes have disappeared and it goes very smoothly. So again, access to justice and cost and efficiency, I can't see. I mean, if it was my client in Europe and I had an expert coming from Germany, I would not really want to pay the freight to have them come over here if they can effectively give testimony from there. That said, maybe I'm old guard. I like the in-person hearings in complex cases. I get a much better feel for the courtroom dynamics than if part of it is in the court and part of it's somewhere else. And my experience with a lot of our colleagues is that I think they feel the same way. So to answer your question in a nutshell, no, it's been very effective. And I see it continuing in the future.
I see that we have a question back on the injunction point, and the fact that there may be more injunctions granted in trademark cases. And the question being is the fact that the defendant in a trademark case can often sell its product under a different trademark pending trial, while a defendant in a patent case is usually kept out of the market and may never recover its market if it wins a determining factor.
I certainly think it's an important factor, no question about it. I wouldn't want to go so far as to say it's a determining factor, because each case is dependent on its facts. So, but that certainly would be an important factor.
One thing that Justice Locke, Justice Manson, that we kicked around a little bit is the notion of kicking the can of the Markman hearing in patent cases again. With the claim construction charts and the efforts to crystallize. Some would say that if you could actually get an early determination on construction, then you could go into not only trial, but perhaps expert reports, I suppose a bit more aligned with US procedure. Any thoughts on that?
Well, I know we, Justice Locke and I will remember, I think Ron Dimmick took the kick at the can and succeeded at our level, and then was told by the Court of Appeal, we are not the United States, we do not do Markman hearings, and that's properly left for the trial judge on a full trial on the merits. So that was years ago. I think we've revisited it in a different context now. I think in terms of summary trial, and I remember it's Madam Justice Gauthier who once said to me when I was advocating the Markman style approach as a question of law, because construction is a legal question, why not do it under the rule for answering that question? And Justice Gauthier, we were having lunch, and she said, "Yeah, well, no, I don't agree with you, Mike. It's not the way. You got to have expert testimony. It becomes mixed fact and law. So unless you've got expert testimony before you, it's not going to work as a pure question of law. It would be better to do it. And this brings us back to summary trial. I think summary trial is probably the more appropriate mechanism to get claim construction determined as an interlocutory issue before the trial on the merits. And that brings me back to injunctions. I'd forgotten. Quite frankly, if you do a summary trial, you're probably going to get as quick and maybe even better relief if you have a strong case to do it by way of summary trial than trying to do it by an interlocutory injunction, particularly in patent cases. So, and I think, again, in our forums with the Court of Appeal, our court, and the bar that we've had in Ottawa over the years, last few years anyway, that's certainly been a suggestion from our court. And I think, again, with the approval from the Court of Appeal, that may be the better mechanism.
Yeah, I agree that since that decision was made years ago, that was prior to Herniak from the Supreme Court. It was prior to the rules on summary trial. So there's much better tools available now. I'm not sure. Have you seen any uptake on sort of a Markman-like motion recently?
I haven't. I mean, I had that one. I'm trying to remember. I keep mixing them up. I think it was the Viv case where it was a pure question of claim construction brought on summary trial, where I found that I could decide the issue of claim construction, and the Court of Appeal upheld that decision. And that was a pure claim construction issue. So there's one case at least that's gone down that road, and I don't know if we're going to see more in the future.
I have a question that's come in. Do the panelists see the role of the pathonotary evolving as the rules and types of cases change? Anybody?
Evolving in what regard?
Well, I suppose I'll leave it open to you. But
well, I mean, I certainly, the expertise of our prothonotaries, who I believe are soon to be associate judges, and hopefully not too distant future, and we'll get rid of that term. But they certainly have a lot of expertise beyond procedural matters. And I think if they were given increased jurisdiction to hear more of what trial judges do, in other words, expanding the scope of what they do, we may get more efficiency earlier through case management than we currently can do. But that's pure speculation.
I've got a comment on the hybrid issue. It may help to explain some of the issues with hybrid hearings. The main problem with hybrid in the courtroom is that the courtroom needs another camera. When you're remote and not the party pleading, you just see counsel pleading and not the court. I have heard that comment before. Although if you've been in the court lately, it's mostly fiber or plexiglass, so you have trouble seeing people anyway. Fortunately, our audio systems are greatly improved since the start of COVID, so usually you can hear them pretty well, but a lot of the sort of nonverbal cues are harder to pick up than they used to be.
That's certainly a fair comment, and then I think we have to understand that we do need appropriate cameras if we're going to continue in the virtual world at any level. We need to make sure our courtrooms are adequately set up.
I have a question. Oh, sorry. Did you have something to say, Ms. Robinson?
No, I guess I was going to pick up perhaps, and if you'll permit me to ask Professor De Beer about alternative, about ADR in intellectual property cases, and whether your research had indicated any trends. There's court, obviously the court offers, I think, a valuable mediation service for parties, which can result in settlements before trial. Did you observe anything within your research on that topic?
Thanks for the question. Quantitatively, no, because we didn't get into the substance of the reason why a proceeding was ended or disposed of. We didn't know if that was a settlement or a decision or what happened. But qualitatively, yes. I don't want to say all, but a great many of the professionals that we spoke to, senior scholars, the senior litigators, speculated as to that as one of the reasons for a decline in the volume of proceedings at the courts. One of the things that I sort of struggled to understand, however, was that the decline in proceedings, which we measured, as I mentioned to Justice Manson a moment ago, was in the proceedings commenced. So as soon as a document is filed. So that wouldn't account for proceedings that are commenced and then through case management, the issues are narrowed and then they're settled and discontinued for that reason. It's a decline in proceedings that are started in the first place. So our hypothesis there was that there are certain difficult issues, genuine ambiguities, which typically lag legislative change by a couple of years. And then, you actually do need to initiate an action and then that provides the basis to bring a motion or whatever to resolve the ambiguity. And then there are other fields, once they become relatively settled, where commencing the action it's not even necessary or appropriate because there are no sort of legitimate legal questions. It's purely factual. The other thing that was suggested to us in our research was that it may correspond to the value of the litigation. The higher the stakes, of course, the more complex and time-consuming that ADR becomes. For the simple matters, they may be resolved without a lot of assistance. So we just barely scratched the surface of this topic as one of the explanations for the data we found, which was quite frankly surprising. I mean, we only started looking at this because we were surprised that the volume of cases wasn't skyrocketing, which was my preconception going into the research.
Building on that, there's a question on our list here that could go to everybody, but I'll start with Professor De Beer for his thoughts. Have you considered that whereas in the 1990s, Apotex and Novofarm were privately Canadian owned and prepared to litigate, and there were many more pharmaceutical companies which have been consolidated? I'm not sure effectively. That now we've got lots of consolidation, not as many players. Do you see that having an effect?
Well, again, only sort of impressionistically. We didn't have quantitative data to back this up because we didn't get into the question of who was litigating against whom. But in our qualitative research, I did frequently hear comments about the litigiousness of particular parties being a potential explanation for ebbs and flows in the patterns that we were seeing.
Well, I just on the point of ADR, certainly, lots of patent cases settle. Lots of them settle with the help of the court's mediation service. I don't have a lot of experience with taking patent cases into ADR. Outside of that, to actually engage a mediator or an arbitrator. So it would be very interesting to look into that. And I don't know if folks in our audience have any experience. I certainly don't. Justice Manson, Justice Locke, any?
I mean, I've done a few mediations, some one or two successfully, one or two not so. They haven't been really prevalent. That being said, I know that our Chief Justice has openly and repeatedly encouraged parties and counsel to consider ADR, both through the court or even privately through experienced IP professionals. So we, as a court, always are encouraging parties to explore ADR as a means to resolve the dispute without having to go through litigation.
Yeah, I had a brief and 100% unsuccessful career at attempting ADR, attempting mediation with the court. I don't know. I did it a few times. I'm not sure if I should take it personally, but I did it a few times. None of the cases settled the day that I was helping. I think there may be a couple that settled later. So I guess maybe I could take some credit for that. I felt depressed trying.
I want to make one comment with Professor De Beer had raised earlier about, where are we going in numbers? And I think he's absolutely right that we haven't seen the influx that we expected, but we may well in the very near future. The Madrid Protocol and opposition appeals, there's been an expectation we're going to see a lot more trademark opposition cases coming to the courts. We've got the AI and digital technologies and as well as biotech really coming into the fore now. Biotech companies and biotech, never litigated much, or it never went anywhere because it was so experimental or in the non-commercial phase. That's changed a lot in the last few years and is going to continue to change, certainly after this pandemic and what's been going on and combating viruses. But historically, it's been oil and gas and pharmaceuticals, certainly recently, that have been driving patent litigation. I think we're going to see a change in the next 5 to 10 years where it is going to be driven more by the digital technologies and biotech.
But I certainly agree with the principle that changes in the laws and regulations can have an important effect on the amount of litigation that's happening. We've just had it's out now, actually a few years old, but the advent of the changes in the PMNOC regulations prompted a lot of litigation that was about uncertainties that allegedly came out of those changes, and I still see them. The new certificate of supplementary protection provisions are brand new. We've started looking at those, but I don't anticipate that it's the last time. I've also seen disputes over the extent to which a prosecution history can be considered. And so that I'm sure there'll be more discussion in that area as well. So yeah. And Professor De Beer, did you have something to say?
Well, I just wanted to say that I think to me, one of the points I wanted to emphasize in this hypothesis and future work that I hope to do is try to do a better job of tracing the stages of that legislative reform from very often. Again, I don't want to say always, but very often those legislative reforms are triggered by international treaty obligations. So all of those examples that were mentioned, reforms to the PMNOC process, CSPs, trademarks, that was all CETA. And so when we look over the last 25-year period, it's NAFTA, it's CETA, it's NAFTA 2.0, CUSMA. These international treaties are what trigger the requirements for domestic legislative change, and then that it's a lag. It doesn't actually show up in litigation for a period of time after that, but it's a really important thing to consider and factor into the policy decisions before contemplating all of the pros and cons of these changes. And I'd like to encourage us to look at that a little bit more holistically, but that may be a comment for a different audience.
And I think Justice Locke, I was just going to mention that we'd all recognize, even based on your remarks that opened the day, that copyright is such a complex area that's really just on the, hand in hand with some of the technological changes. We haven't had an opportunity to scratch the surface of that very much today. It could be a whole other webinar.
Yeah. And it could well be. And unfortunately, that's what I was just about to say as we've run out of time. There's a few questions that we didn't get to, but I guess it's better than running out of questions. So I'm going to close it with a thank you to today's panelists for their participation. As this is the last of our seminars or webinars on behalf of the Chief Justices of both courts and the 50th Anniversary Committee. I'd like to thank all the panelists of the series of webinars for their presentations, as well as those who contributed so effectively to the book launch. Nous en sommes rendus à la toute fin de nos activités automnales pour le 50e anniversaire des cours fédérales. Ce fut une réussite et je tiens à remercier tous ceux et celles qui ont participé au lancement du livre et aux 3 webinaires. I must also express our appreciation to the NJI for its valuable services. Their input and overall knowledge helped in making the webinars and the book launch a real success. Et un gros merci à notre partenaire, l'Institut national de la magistrature. Leur participation fut essentielle. Looking ahead, the next dates to reserve on your agenda are June 27, 28, and 29 of 2022. On se revoit les 27, 28, 29 juin pour la conférence en personne à Ottawa. The in-person 50th anniversary conference, originally scheduled for June of this year, will now take place, fingers crossed, next year, and will ultimately be accessible via the internet. Cette conférence sera accessible en ligne. The 50th Anniversary Committee, in collaboration with the NJI, is currently working on the conference program, which will be announced in the new year. Le programme de la conférence sera dévoilé en 2022. Thank you. Au revoir.